Cool. Is my PPT in screen share mode, like slideshow mode?
Yes, it is.
All right,
Yes.
perfect. Okay. So, just a disclaimer, you guys will understand this as we. Can everyone turn off their mics?
Subramaniam.
Uh, right. Okay. So, you guys have still not done any intellectual property subjects yet. So, as you do it, you'll start understanding the kind of importance of giving notice to prevent infringement, right? In front of before a movie, also you see the disclaimers, right? That this is copyrighted material. Nobody is allowed to infringe this or copy this or sell this, right? Okay. Satyanarayan is also here. Cool. So I'm also offering disclaimer to this PPT that I'm presenting here. And the problem is when you don't serve a notice like this, you can use the fact that you have not served notice as a defense in an infringement proceeding later on. As in, like, suppose I don't show this notice, people will infringe later on and say that, oh, I did not know it. The person did not serve me a constructive notice. So this is why preemptively you always serve a notice. You'll always see these kind of disclaimers at the start of any artistic work or a literary work, stuff like that. Cool. So starting off, okay, so we'll discuss all the basic concepts in patents. Okay, so if you actually take out the act and you start reading it, it's very difficult. Like when I actually went through it, it took me like at least 5 or 10 times of reading it again and again and again to even understand the basic concepts that are involved, right? So if someone can actually give it to you in a visual format, it's very easy to understand the concepts, and once you know the concepts, reading the act is very easy, right? Because the act is not structured at all, it's extremely chaotic. Like sections are just jumbled together, everything placed in a very chaotic order. So try and understand the concepts, and once the concepts are very clear, like try and create a visual image in your mind. So once the concepts are very clear, then you'll be able to understand the act extremely easily. Okay, and understanding the patents act is the cornerstone of clearing the patent agent exam. You need to know the act inside out. Okay, the patents act has to be your best friend. Cool. So starting off with all the basics in patents, right? So you guys have already done property law, right? So in property law, what kind of things can we own as property? You guys would have studied about tangible property, right? Tangible means something that is physical, as in property that I can touch and feel, right? Something that exists physically in this world. And that you have two types. One, you have movable property, as in my bike, my car, the textbooks I have, my computer, my laptop, my pen, stuff like this is called as movable property, right? And then you have immovable property, stuff that you cannot move around, right? Something that is fixed to the earth itself, your house, a building, a factory, right? Or a school. These are all immovable property. Okay, so now that we have covered tangible property, what is the other kind of property that we have? We have intangible property. Okay, property that does not have physical existence. Okay, so it is something that is abstract in nature, as in it exists. I can't say that it exists in mind because it exists also physically, but in a intangible manner. Okay. An example of this would be creative works. Okay. Suppose I create a musical composition, right? Or suppose I write a story, right? This is not something that can be physically passed. I cannot give it from my pocket to your pocket, right? This is something that exists intangibly, right? A creative work or something such as an idea, as in suppose I've developed a new way of administering a drug, right, or a vaccine, or suppose I've invented a new form of robot or a new kind of machine. So this is an idea, right? So even this is something that is intangible. And thirdly, brands. Suppose I make a shoe, okay, and I it costs me 80 rupees to make, and I sell the shoe to you guys for 100 rupees, right? But suppose I put the brand name Puma on the shoe, then suddenly the shoe's value becomes 8,000 rupees, right? So can you understand that the value that this brand has brought has been around 7,900 rupees now, where 100 rupees has gone up to 8,000 rupees just because of this brand. So even the concept of a brand is intangible, right? But it has value. So all these three come under intangible property: any creative work, any idea, or any brand. Okay. So again, all these cannot exist in your mind. I can't say, oh, I have the most brilliant story in my mind. Now give me money, right? It has to be put forth into the world. As in, if I have an idea, it has to be put forth on paper. I'll have to produce it and show it to the world. Okay. Only then the idea will be protected. So today we're going to be talking about patents, right? So patents fall under ideas, what that we try to protect. Okay. So very simple. In patents, let's say I've built a new kind of robot. Okay, a robot that will come and do your work. It'll help you out. It's the most advanced robot. Okay, so the robot itself is protected by property law. Why? Because the robot is it's my movable property, right? I can move it from place to place. I can sell it to you, sell it to somebody else. So the robot's physical existence is protected by property law. Just a second. Cool. Okay.
Which one?
Huh.
Are you recording it?
I'm not recording it, unfortunately. I'm taking a transcript of it, but recording is not possible.
Okay.
Hmm.
Oh.
Cool. So suppose I build a robot, like I told you, I will be able to sell the robot to you, right? Or I can prevent somebody from coming and stealing the robot. So the robot is protected by property law because it's a tangible property, right? But what about the idea of the robot, as in like all the technical features of the robot? Suppose I've installed a sensor over here, some kind of camera here, the software which is running the robot, or what kind of material I've made used to make the robot. All this, okay. Suppose I put it in my robot. How will I protect this, the idea of the robot, right? That is where patents law steps into play. Okay, so how I'll be able to prevent others from stealing my robot using property law? Using patent law, I'll be able to protect the idea of the robot itself. As in, I can stop other people from copying my robot. That's what a patent brings to you. Okay, it gives you an ability to protect your ideas. Okay, so and in India we have the Patents Act 1970. So this is the legislation, like how you have the Transfer of Property Act for property law. In India we have the Patents Act 1970, and patents enable a patentee to protect their idea from infringement by other people. Okay, so where all does the patent give you protection? What kind of protection does it give you? Firstly, patent rights are territorial in nature. Okay, just a second, somebody else is coming in. Right, Subramaniam is joining from 5 accounts. Cool, cool, cool. Okay, so where
So
all?
where all?
Remove him from every account.
Okay, okay,
Okay,
cool,
okay,
cool.
cool, cool.
Mute yourselves, please. Yeah. So where all do you get protection with a patent? Firstly, patents are territorial. Suppose I get a patent in India, then the protection is available only in India. Okay. So I can't go to America and enforce my Indian patent. Or suppose I get a patent in Pakistan. I can't go to Sri Lanka and enforce my patent in Sri Lanka. Okay. So patent rights are territorial in nature. Suppose I get a patent granted to me in India by the Indian Patent Office. Uh, then I cannot assert the rights of that patent abroad. As in, somebody else in Africa can infringe on my patent. Suppose the robot I have built in India is patented in India, but still somebody else can remake and sell that robot in Pakistan. I cannot stop them unless I go and individually apply again in Pakistan, and then I can stop the person infringing it in Pakistan. Okay, so what you have to do is individually you'll have to go to different countries separately, and you'll have to apply for the same patent. Okay, so this is something called as a patent family. So I have a patent for a laptop. I'll apply for the same patent in India, in Japan, in US, and in Europe. It's the same invention, right? So all these patents in different countries for the same invention are called as a patent family. Okay, very very simple. Then how long is the duration of protection? So for a patent, it's always 20 years from the date of you filing the patent application. Okay, because it's very arbitrary, right? Let's say I start inventing this robot in 1980s, and then it takes me 40 years to develop it. Then I start selling it to like a few people. Then I enter the market and I sell it to like millions of people. So at what point can you say the patent has gained power, right? So you'll have to fix a starting date. So this starting date is fixed from the date of filing your application. The day I fill up my application form saying that I'm going to file a patent, I describe my patent completely, and then I submit it to the patent office. The date on which I file it, that is the date on which the clock starts ticking. And 20 years from that date is the duration of the patent. Once the 20 years lapses, the patent completely exhausts itself. As in, you cannot use it to enforce any rights. All the technology, all the inventions that you're trying to protect will enter the public domain. As in, my robot, after 20 years of the patent getting lapsed, everybody can copy it, everybody can sell it, everybody can buy it, do anything with it. Okay, because the patent has completely exhausted. Who else is this? Udit. All right. Cool. I'll take doubts in different sections. Okay. So yeah, just the last concept before I take it out. So you guys know that patents last for 20 years, right? So what is this arbitrary number? Why did people come and fix this 20 years, right? So there always has to be a balance of public interest and private interest, right? Private interest as in I'm the inventor. I've spent a lot of years of my life studying in IIT. Then I've worked on my own. I've developed this technology. I've spent crores of rupees and I've developed an invention. Okay. So now I don't want to share it with anyone. So if I share it with anyone, I know they'll start copying it, and there's no point in me making the inventions, spending so much of time developing it, because the next person is going to copy it, right? So I'll have to try and protect my private interest. So what will I do? I'll hide the invention. I won't show it to anyone. I'll privately sell it to like 2 or 3 people. I'll sell it for like crores of rupees. Cool. So what is the public interest? So the public interest is I have to benefit society, right? Suppose I've invented something. I'll have to share it with society itself, right? Otherwise, how will science and technology advance? How will society progress? Suppose everybody is hiding their inventions. Suppose I invent the COVID-19 vaccine and I don't show it to the public, or I don't manufacture it or distribute it in the public. Then how will the public benefit? Everybody will die of COVID, right? So how will you incentivize the inventor to come out and give out the invention, right? By giving a balance of rights. Firstly, you tell the inventor, cool, you disclose your invention. Please don't hide it because we want society to benefit. But in exchange, we will give you a 20-year monopoly. Okay. I can't give you a permanent monopoly because if you give a permanent monopoly to an inventor, that's it. He's going to sell it for crores of rupees for thousands of years, right? The public will not be benefited. So you'll have to balance it out where you give him a monopoly, but only for 20 years of time. Okay. Again, 20 years is an arbitrary number. It was fixed in WIPO under the TRIPS agreement, and all the countries have to follow it now. Okay. And I think, as far as I'm aware, 20 years is a minimum time period. Okay. So if a country chooses it, can extend it more also, but 20 years is what every country offers. So the public interest is where the public needs the invention to be fully disclosed to the public. Okay. And the invention has to be utilized for the public good. And the invention has to be available also to everyone at a reasonable cost. Okay. So understand this concept properly, because when we reach the advanced patents presentation next week, you'll need this to understand what compulsory licenses are. Okay. So what is the private interest? Since I've spent so much of time and money and resources into developing this robot or this vaccine or this invention, I need to get some kind of incentive, right, to disclose this invention. So the government gives me a monopoly. And once it starts doing this, what does it do? It encourages people to start inventing, right? Because now I get 20 years of time period to exploit my invention where nobody else can copy me, and I get to reap all the benefits of their invention, right? So now there's an incentive for people to invent and innovate. So there is a technological advancement of society itself, right? So by ensuring the public interest, there is a private interest also ensured. And by ensuring the private interest, you also ensure the public interest. There always needs to be a balance. And this concept you will study in all forms of IP, not just in patents. You'll see it in trademark, you'll see it in copyright again, you'll see it in designs as well. Okay. There always needs to be a careful balance of public interest and private interest. Cool. Any doubts up till here? Okay. I'll be moving on. Very simple. Just relax and go on, please.
Yeah. In the previous slide, you said that we have to protect patents separately in different countries. Can foreigners apply for patents in India? Okay, and the other way around?
Yes. Okay. So any person can apply for a patent in India. Even a foreigner can apply. Even a juristic person. You would have studied in constitution, right? Even companies can apply for patents. So let's say I got a job in TVS now. So the applicant will be TVS Motors India. Okay. So it can even be a juristic person. It doesn't even have to be based in India. Okay. So this we'll study in the advanced concepts, because when you have to apply in different countries, there are two ways to do it. Okay. One is through the Patent Cooperation Treaty, PCT, and the other is through the Paris Convention. Okay. So there are two routes to apply internationally. This is something that's slightly more advanced. We'll discuss it in the next meet. Okay. So it's a great question to ask, actually. Foreigners can apply for patents in India. Cool. All right. So I'm going to be covering a lot of concepts. So just sit and listen to it like a story. Okay. Cool. So what can you get a patent on, right? Can I get a patent on anything? Let's say I write a storybook. Can I get a patent on that? I don't think so, right? Suppose I shoot a movie. Let's say I record a movie with Hrithik Roshan and Deepika Padukone. I watched a very unholy trailer yesterday, but chalo, can you get a patent on a movie like that? Of course you can't. Okay. So what can you get patents on? You can get it on inventions. Okay. And inventions are two things. One is a product and second is a process. Okay. A product is anything. I've just listed out all the kinds of examples which came to my mind. A product would be any kind of a machine or a device or a gadget. Let's say a computer or my electronic smartwatch or my mobile phone, or any kind of medicine or a vaccine or a drug or any kind of chemical. Let's say I invent a new form of ointment, right? Or some form of chemical that reacts in the sun, some kind of photosensitive chemical that I'll use for giving a coating, right? Or any form of man-made microorganisms, as in I've synthesized it. Let's say like China synthesized the COVID virus, right? Again, don't quote me on this. I have no proof of this. Let's say I invent a new form of microorganism, new form of bacteria. And there was a patent also filed by Honda regarding this, where they invented a kind of bacteria which eats up oil, okay, which eats up ethanol. So where you'll apply this bacteria is in the oceans where oil spills occur. So they'll release this bacteria, it'll eat up all the petroleum and it'll clean the ocean. Okay. So any form of man-made microorganism, it can't be found in nature. Okay. It has to be something that is synthesized artificially. Okay. Or any form of software. So software is something very contentious. Okay. So let's say a software program, let's take WhatsApp or Facebook or Google, the Google search algorithm, right? something that's very contentious. A lot of countries don't allow software patents. Even India has started allowing only since 2019. Okay, only in 2019, Fred Alani versus Union of India, Delhi High Court opened the doors for software patents. Okay, even then it's very hard to get it, and very contentious. Even the US is not fully firm-footed yet. You'll study a lot in your third sem. Okay, so products you can get patents on, and secondly, processes, as in a process which is used to obtain a product also. Okay, so a lot of people, what they do is they file two patents. Whenever they invent something, they file two patents. Firstly, for the product itself, and secondly, a method to make that product. Okay, so it gives you better protection, right? You get a larger ambit of protection now. So a process could be any method of production, any method of manufacture, synthesis. Let's say firstly you do some drilling process, then a boring process, then you do a curing process, then some form of thermal conditioning. So all these methods collectively form the process itself. Okay, any form of new method of cultivation of some kind of animal or some microorganism, not animal, sorry, any new cultivation process for a bacteria or any application of a product, right? All these come under process. So you can get patents on products or processes, right? So there are three requirements. Firstly, this product or process has to be novel. It needs to have an inventive step, and lastly it needs to have industrial application. Okay, so this trinity, this triad of requirement is what is most important for a patent. Okay, if you don't have these three, you can never get a patent on it. So your invention can either be a product or a process, and these product or process needs to have novelty, needs to have an inventive step, and it needs to have industrial application. Okay, I'll explain all three in a bit. So let's say you get this patent on a product or a process. What rights does it give a patent holder, right? Firstly, if it's a product, you can prevent any third party without taking your permission from either making that product, from using that product, from even offering for sale, not just selling, even offering for sale. You would have studied it in contract law, right? Where a chemical was placed in a drugstore, but it was an offer for contract, right? It wasn't the contract itself; it was an offer for making the contract. So even offering for sale, even that is illegal. And even importing it to India. Suppose the patent is in India, but you're trying to get it from source it from a foreign body which is abroad, right? It's a little complicated. You'll understand it once we do the international applications next week. Okay, so all these things are illegal. So let's say I have a patent on a mobile phone. Okay, so I can stop Subramaniam or Uttam from making it, using it, or even offering for sale, or even selling it, or even importing it to India without my permission. Okay, for everything they'll have to come to me for a license. Okay, and if it is a process, from using that process, or when you use the process, you make a product, right? So anything which is made from that process, any product which comes from that process, from making that product, using that product, offering for sale, selling, or importing to India of that product, which comes from that process, right? That is the right of a patentee. So very simple. So once you get a patent on a product or a process, you can stop third parties from basically using or selling or making that product or process. Cool. Cool. Now we come to the three requirements, basically novelty, inventive step, and industrial capability. Okay. So novelty is something very simple. It has to be something new, right? Can you get a patent on something that already exists? Can I get a patent on Whirlpool's washing machine that's already there in the market? You can't. So it has to be something new. Okay. Something which is not yet published in any research paper or publication. Understand this. It can't just be another invention. It shouldn't even be written about in some book. As in, if somebody's written a textbook about my new solar powered mobile phone, then I still can't get a patent on it because somebody has already written a book about it, right? It's not something new. Or it should not be used anywhere in the world. Even if it is used somewhere in Africa, it has lost its novelty, right? Although I'm applying for the patent in India, if it is used somewhere else in the world and it has been recorded and people know about it, right? Then it's not something that's new, right? It has lost novelty. Something that has not fallen in the public domain. Public domain means all of us already know about it, right? Let's say somebody else has got a patent on a new form of electric scooter, okay, and the patent has expired after 20 years. Now after 20 years it has entered the public domain. Everybody's using it now. Once it has entered the public domain, I can't go and file another patent on it, right? Because people already know it. So the novelty is lost. And lastly, it should not be part of the state of the art, as in like, it should not be part of the existing technology. Always, what does a patent try to do? It tries to bring some form of advancement, right? It has to be something new from what already exists. So that's what novelty is. Something which is slightly new from what is already existing in the state of the art today. Okay. And when should it be new? It should be new as of the date of filing the patent application. Okay. Let's say I file the patent application today on December 10th to 2023. Okay. And I filed the patent application for a new form of roller skates. Okay. Some form of solar powered roller skates. I file it today. Let's say day after tomorrow, somebody writes a research paper on solar powered roller skates. That's totally cool. I still have the novelty because I was the first person uh, who filed the patent for that invention when nothing else existed. Okay, so novelty is there in my invention. Okay, so all these things, okay, where it has already been published or it has been used somewhere or it has fallen in the public domain, all this is called as anticipation. Okay, so what is anticipation? Suppose I come to your house for dinner. Okay, I don't tell you and I come tomorrow night for dinner. You'll be very surprised, right? You won't have any food for me. You'll have to order on Swiggy something probably, but you're pretty screwed now because I've told you, I've come without telling you, right? Let's say I inform you beforehand, 1 week before I send you a WhatsApp message, the day before I give you a phone call. So on the day of the dinner, you are anticipating my visit. Correct? You are expecting that I'll be coming for dinner that day. So you'll buy all the vegetables, you'll buy all the drinks, this, that, all the food. You'll prepare the dining table, and you'll be ready for me, right? So when an invention has already been spoken about in a research paper, or somebody else has used it somewhere in the world, or it has already entered the public domain, or it's already part of the existing technology, then don't you think that invention is already anticipated, right? In which case, then there is no novelty in it, right? So whenever you use the word novelty, you'll interchangeably use the word anticipation, because if something is anticipated, then there is no novelty to it, right? So for something to be novel, it should not be anticipated, except there are four conditions, I think 4 or 5 conditions in section 9 to 29 to 34, where they give certain exceptions to anticipation. Okay, we'll discuss it next week, but just a quick example of what it might be is, let's say I am the researcher and I have published a paper on solar powered roller skates, right? And next week I only file the patent application, right? Since I am the inventor and the paper that I publish is my own, right? So in this case, even though it is anticipated, there is a certain exception because the inventor himself is the person who published the paper. Okay, but again, there's a certain criteria. I'll still have to file the application within 12 months of publishing the paper. Okay, so they do allow certain exceptions to anticipation, but not too many. Okay, so they allow it only majorly in cases of self anticipation, where I myself anticipate my own invention. I only publish a paper, I only make a YouTube video, and then I go for the patent itself. Cool. So let's say an example. I make a research paper. I write a research paper on solar cells, which use gold wafers. Okay, it's something that's new. And this research paper was published in 2009, 1st Jan 2009. Okay, and then a, like 10 more than 10 years later, a patent application for solar cells using gold wafers has been filed on 1st December 2023. It's not novel, right? Because why? This whole concept, this whole invention has been anticipated, right, in the research paper which came out in 2009. So novelty has failed. You will not get a patent. Okay. So just a quick example. Let's say there are tables, right, today with 4 legs. Okay, let's say I'm very smart now, so I want to get a patent on something very faltu now, some altu faltu patent I want. So I just install one more leg. So all of you guys have heard of 4 leg tables, right? And you would have also heard of 6 leg tables. So I'm going to be a little extra smart and I'll invent a 5 leg table. Okay, a table with 5 legs. Okay, it's not 6, it's 5 legs. So I add the 5th leg because it gives it more load capacity. Okay, it can take more weight. And 5 legs, nobody has seen in the world. Which idiot has a 5 leg table in their house, right? It's not in the public domain. I'm 100% sure nobody has written a research paper on a 5 leg table. So do you think I'll get a patent on this? Cool. So let's say there's a tap, okay, with one head on it. So have you seen a tap with 2 heads? You might have. Okay, let's say there's a tap with 3 heads. Okay, so this is my invention now. So it allows me to wash my hands very fast now because there are 3 heads. There's more flow of water. I can wash my hands very fast. The Lifebuoy ad will be much faster now because I get 3 sources of water now, right? So can I get a patent on this now? It is something novel, right? It's something new. It's not been anticipated. So what do you think? Is there novelty in this case? So the answer is yes, there is novelty. Okay, it is something that is new. Okay, but is it still eligible for a patent? Which is when we go to the next step. Okay, inventive step. So it's not enough for it to have novelty alone. It needs to have inventive step and it needs to have industrial application. Okay, so these two are novel. Basically anything new. Suppose I come with an orange shirt instead of a red shirt. I am still novel, right? I'm still wearing something new. But is it worthy of a patent? That's what we'll see now. Cool. So the next step is inventive step. So what is novelty? Something new, right? So an inventive step is some progress, as in some advancement. So what would be an inventive step? As in like where I take something and I advance the technology a slight bit. It doesn't have to be too much, a little bit of advancement to the technology itself. So it can be any technical advancement to the existing knowledge, or it should have some form of economic significance. Okay, let's say I take a laptop and I invent a new okay, let's not take a laptop, let's say a solar cell. Okay, solar panel, and I install some kind of new kind of radiator in that which makes the solar panel 10 times more efficient. okay, or I install some kind of component to it which makes the solar cell much cheaper, right? So there's economic significance to it, right? So it can either have a technological advancement or it can have some form of economic significance, but both of these has to be not obvious to a person ordinarily skilled in the art, okay, or a POSA or a POSA, a person ordinarily skilled in the art, okay. So what this means is when I make some form of technical advancement, it has to be something which is not obvious to the normal person, okay, and a person skilled in the art, as in a person who's working in that industry. Let's take an engineer who's, let's say I have a new kind of bike invention, a new form of bike engine, okay. I make a small modification to the engine and now it's a new invention. There is novelty, okay. But this new modification I've made has to be not obvious to a person who's already skilled in the art, as in some other bike engineer or some other mechanic or some other technician who's working in a bike company. It should not be obvious to them. It has to be something not obvious, as in something new, right? Because if it's obvious, what's so great in it, right? Anybody can do it. So it has to be not obvious to a person ordinarily skilled in the art, okay. And what do I mean by ordinarily skilled? As of the date of application, okay. Let's say I filed the application in 2018, okay. Lot of times, you know, right, how the Indian government offices work. So the Indian patent office is also government office, so it will take a lot of time for me to actually get the granted patent, right? It might take 3 years, it might take 4 years, it might take 5 years. So in which case, don't you think everybody's technical capabilities increase every year, as in like an engineer in 2005 and an engineer in 2015 and an engineer in 2025, don't you think their skill level is increasing every decade? So a person who's ordinarily skilled in 2005 might not have the same skill set as a person who's ordinarily skilled in 2015, and he might not have the same skill set as a person who's ordinarily skilled in 2025, right? So at what date do we take what the skill level of an ordinarily skilled person should be? We'll take it as the date of the application. So in 2018, when I filed that patent application for a bike engine, on that date, right, what was the ordinary skill level of the persons who were ordinarily skilled level, ordinarily skilled in that time period in that industry, right? So we refer to that time period when the date when the application was filed, okay. If it was not obvious to a person who was skilled then the patent has inventive step, okay. So it could be either better qualities and characteristics, as in like suppose I've improved the material, I've given it some kind of thermal coating, or it has become much more stronger, or it has become much more durable, or it's become much more ductile or malleable. Suppose I've improved the qualities of the characteristics, it has inventive step, right? Suppose I made the material more cheaper to manufacture. Suppose I've instead of using metal or aluminum, I've taken a cheaper polymer, or I've used some kind of plastic, so it has become cheaper, right? So that's also an inventive step. And nowadays, even if you make something more eco-friendly, as in you have reduced the emissions, or you made something more environmentally friendly, that is also qualified as an inventive step, okay. So when I talk about a person who's ordinarily skilled in the art, we're talking about a person with ordinary knowledge and skill. We're not talking, of course, there'll always be oversmart people everywhere, right? There'll be some engineer who knows as much as Elon Musk. We're not talking about them. We're talking about a basic level engineer, a basic level technician, a basic level mechanic. We're not talking about Albert Einstein. Okay. So this is what I mean when I say it has to be not obvious to a person ordinarily skilled in the art. So coming back to the previous example, okay, like the same thing I said, suppose I filed the patent application on 1st Jan 2010, then it should not be obvious to a person ordinarily skilled in the art who's ordinarily skilled with respect to the year 2010. Okay, cool. So the same example, the table with 5 legs and the tap with 3 heads. Okay, so there is novelty, right? We agree on this that it's something new. But is this something that is not obvious to a person ordinarily skilled in the art? To my knowledge or to the common sense understanding, adding extra legs to a table will of course increase the load capacity, right? So of course this is obvious even to a child. What do you mean to an ordinarily skilled person? So of course adding more heads to a tap will of course give more water, right? There will be more flow. So this is also very obvious to a person who's ordinarily skilled in the art. So this is obvious even to a child, right? So of course there is no technical advancement in this case. Both are obvious to a POSA. So in which case there is both of them lack inventive step. There is no inventive step in both of these inventions. So both of them are not eligible for patents. Okay. So although both have novelty, both of them do not have inventive step. Therefore, they are not eligible for patents. Okay. The last thing, very simple, industrial application is you should be able to manufacture it in a factory for mass production. Okay. It should be something which is capable of manufacture, as in capable of production in an industrial scale, as in I should be able to produce it for the masses. It should be the product of the process that I'm trying to patent, should be able to replicate it and mass produce it and sell it to consumers on a large scale. Okay, this is not a very strict requirement. So why they keep this is just to keep away frivolous inventions. As in, like, you have like rubbish people who come and file a patent on some form of bread making machine, some kind of rubbish machines, just to get a patent for it, just to put it on the resume that they are a patent holder. They come with frivolous inventions which are completely rubbish, right? A spoon which will cool down your soup, or a fork which will act as a spoon. So all these rubbish inventions, to keep away the patents from them, you bring this requirement of industrial application. It's not very strict, and very rarely patents get struck out because they don't have industrial application. So just summarizing, you need to have novelty, you need to have inventive step, and you need to have industrial application. Novelty means something new. Inventive step means some kind of advancement, okay, some technical advancement or some form of economic significance which is not obvious to a person ordinarily skilled in the art. And lastly, industrial application as in capable of being manufactured on an industrial scale. So if you satisfy all three, you can get a patent on anything. Cool. Any questions? All right, let's proceed. Okay, very simple example now. Let's say there's a helicopter. Okay, can I get a patent on a helicopter? Of course not, right? This is something that exists in the public domain for ages together. Let's say the propeller part of the helicopter is there, okay? I just want to take that and I want to combine it with some other article, okay? Let's say I take the propeller of the helicopter and I combine it with a cap, okay? And I fix it on the cap and now I can fly now, right? So what I've invented is a bamboo copter, right? So is it possible to get a patent on a bamboo copter? Do you think Doraemon is eligible for a patent on a bamboo copter? Okay. So do you think this is something that is novel? Because I definitely don't think. Okay, assume that Doraemon has not come on TV. Okay, because if Doraemon has come on TV, it has been anticipated technically. Okay, so let's say Doraemon has not come on TV. Nobody knows about bamboo copters, and suddenly people are talking about bamboo copters, and I invent it. I get a patent on it. So definitely there is novelty now, right? I've taken some an existing invention. I take a helicopter. I take an existing item, a cap, and I combine both, and I invent a bamboo copter. Of course, it's novel. It's something that's very new. It has not been anticipated in any research paper, no other invention. Does it have inventive step? What do you guys think? Do you think combining a propeller to a cap is something that is obvious to a person skilled in that? Of course, it's a technical advancement, no doubt about it, right? Firstly, you have a helicopter that you can wear on your head. Secondly, you have a cap that can make you fly, right? Of course, it's a technical advancement, no doubt about it. Is it not obvious to a person skilled in the art? Definitely yes, right? Who on earth will ever think about this? So it's definitely not obvious to a person ordinarily skilled in the art. Maybe some Albert Einstein, Stephen Hawking would have thought of it, but to the ordinary person, ordinary skilled person, this is not obvious at all. So there is inventive step. And lastly, is it capable of industrial application? Why not? I can put it up in a factory line, I can mass produce it for everyone to use, right? If I'm correct, I think Doraemon himself has like 4 or 5. He gives it to all of Nobita's friends, right? So definitely there is industrial application to this. So for a fact, I can tell you bamboo copter is eligible for a patent in India. Okay, cool. So is this much clear? Any doubts? All right. I guess everyone watches Doraemon. Cool. So we have these three basic requirements, right? Novelty, inventive step, and industrial application. Cool. So apart from that, anybody?
Yeah, I have one doubt.
Go on, go on, go on.
Actually, you said like because it has appeared in the cartoon, that's why it is not eligible for like, because that's why it is anticipated.
Hmm. Yeah. Okay. So what anticipation means is if anybody has spoken about it or talked about it or shown you the invention beforehand, it's not something new, right? So of course, all of us have watched the Doraemon cartoon and the bamboo copter is there in the cartoon, right? So as a joke, yeah, technically it has been anticipated. It has come in the cartoon, right? So it's not something new then. It fails novelty there. Okay. So assume that the Doraemon cartoon did not exist and I have invented Doraemon has come from the future and invented the bamboo copter. Okay. In which case it is something that's new. Okay.
Okay.
Okay. Another example of this could be
Vishnu, I think it should be published in such a way that the person ordinary skill in that should be able to make it without any other external help. Then only it will be treated as, you know.
okay. That comes in the disclosure requirements. That's yeah, what you said is correct only, but that's a different requirement. We'll study it later on. But just for the basic understanding of novelty, okay. Again, don't dissect my example so in depth. Of course, some research paper might have come out also. As far as I'm aware, Da Vinci has written a lot of blueprints and inventions of flying devices that can make you fly. Okay. So technically it's not possible to come up with something like a bamboo copter and claim it's novel. Okay. Maybe it does exist. I don't know about it, but I'll give you another example. Let's say there's a what kind of invention has come out? Let's say Shakalaka Boom Boom. Okay, that guy has a magic pencil, right? So I've been watching the show for a long time. Let's say it's a hypothetical example. Let's say today I invent that same pencil now, which I if I draw it now, it'll come into real life. Okay, so technically there is no novelty in that pencil. Okay, because the show has come out, people have watched it for years together. It's already there. The knowledge is there in the public domain. People know about it. Okay, so basically just understanding that, as in do people know about it or not, that's what we're talking about in novelty. Okay, what you said is correct. Regarding the disclosure requirements, we'll cover it a little later in this PPT only. I'll explain it later. Okay, so for you to understand novelty, very basic understanding, is it something new? That's all. It should not already exist, because if it already exists, it has been anticipated. Okay, just understand that much. Cool. Don't go into the nitty gritties. Novelty is not the strictest requirement. Inventive step is the toughest requirement to crack. Okay, so very simple now. So let's say I already told you what all is patentable, right? Any invention which is a product or a process. Suppose, let's say I invent a new kind of bomb, okay? A nuclear bomb. I invent an atom bomb, okay? Can I get a patent on an atom bomb? Okay. Or let's say I invent a new form of killing device, something that will kill 20 people in the same instant. It's a new form of like vaporizer gun. And if you just press the trigger, it'll kill 20 people in the room in 1 second. Can I get a patent on this? Okay. Or let's say I invent a kind of patent which enables cheating. Okay, some kind of forging device, like using it I can steal somebody's identity or something like this. Do you think you can get patents on these things, right? So there's a long list of things on which you can't get a patent on. Okay, so India has a very large list of it, which is listed in section 3 of the Patents Act. Okay, a long list of all the things that you cannot get a patent on. Okay, so India, you also know, right, was a very poor country. We still are a developing country, so India cannot allow patents on certain things, right? You guys can understand yourselves. Let's say I invent a new form of growing rice, okay, rice or some form of food crop, which is very important for the food security of India. So in which case India will not allow a patent on that, right? Because India wants to protect the food security of India. It will not allow monopolies on these kind of things. Or let's say I invent something which is against the public order or morality, right? Suppose I invent a gun which can kill 40 people. Of course, you can't allow patents on these kind of things, right? So every country has its long list of patents which it doesn't allow. India lists all of that in section 3 of the Patents Act, all the inventions which are not patentable. Okay, so let's go letter by letter. It's listed in these letters only, and I encourage you to learn all the letters, because all this comes in the patent agent exam. It comes in the interview also, and it's always something good to know as a person who works in patents. Okay, I've kind of given a way to remember them. Let's see if it helps you guys or not. Okay, so first thing which is not allowed to be patented: A, frivolous inventions and those which are contrary to natural laws. Okay, something which is very absurd. Okay, let's say I invent a new form of medicine. Suppose you take it and you start floating in the air. Let's say I file a patent application for anti-gravity pills. Okay, so this is contrary to natural laws, right? Or suppose I file a patent application for an engine which will infinitely produce heat. Okay, in which case they don't even care if your invention is possible or not, since it is contrary to natural laws, or since it is frivolous, or since it is something that is so absurd, your invention is not patentable. Okay, do not waste the patent office's time. We do not want you. Your invention is not patentable. Okay, so A is any absurd invention. So how you remember it is A for absurd. Okay, absurd inventions are not patentable. Secondly, B, anything which is contrary to public order or morality, or anything which is prejudicial to human, plant, animal life, or the environment, right? Suppose I invent a new form of chimney, okay, which will release 20 times the amount of smoke to the atmosphere. So my invention does nothing. Okay, it only pollutes the environment more, in which case it is contrary to public order and morality, right? It harms the environment. So anything which is bad, B for bad, is not allowed to be patented. Okay, so just a little bit of information for you guys. So there was a mouse, okay, in Europe. So this was a patent filed in the European Union. So they invented a new form of gene which they inject into the mouse. Okay, and when you inject this gene, it gives the mouse cancer. Okay, you'll think, why the fuck would anyone invent such a horrible invention or any horrible gene like that? So why they did this was to inject this cancer producing gene into a mouse and to make the mouse develop cancer. And once you do that, you can study the mouse to develop new forms of cancer treatment. Okay, so this is called as oncomouse, oncology. So oncomouse. So they filed a patent for this gene which induces cancer. So again, a lot of people said that this is something which is contrary to public order. It is contrary to public morality. It's harmful to animal life, right? But in the long run, the patent was allowed, because although it's harming the animal per se, it is benefiting society itself at large, right? Because when you start developing treatments for cancer, it's going to help the whole of society, right? So they allowed the patent in this case. Of course, India will never allow this patent, but the European Union did allow this patent. And hairless mouse also came up. Okay, so same thing, same concept. In the European Union, certain researchers came up with a new form of gene which induces balding in mice. Okay, it gives hair loss to all the mice. Okay, so why they did this was they wanted to study new forms of treatment for balding and for hair loss, right? So in this case, the patent was not allowed because they said that hair loss is not something which is very crucial. It's not going to be something that the public are really looking forward to, and it's not going to truly protect society as much as cancer would. So although we allowed the onco mouse patent, we will not allow the hairless mouse patent. Okay, so the hairless mouse patent was rejected on the public order or and morality grounds. Cool. So B, how you remember it is it's bad. So absurd for A, bad for B, and then for C, any discovery of a scientific principle or theory. Okay, let's say I discovered the speed of sound. Okay, I find out the speed of sound is 1083 meters per second in a metal, so much in liquid and so much in gas. Or suppose I discover the speed of light, right? Or suppose I discover gravity. Do you think you can get a patent on any natural laws? You cannot. Okay, so the laws of physics, anything which is already found in nature, you cannot get patents on. Suppose I pluck a hibiscus flower, can I get a patent on that? Of course you can't, right? Any mere discovery is not a patent. Okay, so how you remember this is C. C is the symbol for the speed of light in physics, right? So C, speed of light. So all the laws of nature are not patentable. Then D, so this is a little more complex. So this is a new form of a known substance, okay, with no increase in efficacy. So what this means is, just one more example I've written down. So mefloquine is a drug, okay. So mefloquine was used as a treatment for some kind of disease, okay, for a long time. It was patented and all that. People used it, and everything was fine. The patent expired. After a few years, they discovered that mefloquine can be used also to treat malaria. Okay, so this is a new use, right, of a known product or a process. So since it's a new use, a patent was allowed on mefloquine. Okay, all this is abroad. India will never allow this. So in India, a new form of a known substance is not allowed, or a new use of a known product or process also not allowed. So if mefloquine was brought in India and they said that, oh, we can treat malaria now, it's not at all allowed. Okay, so a new form of a known substances. Don't you think? Suppose I have a chemical. Suppose I have fluorine. Okay, I can make fluorine oxide. I can make fluorine chloride. I can make fluorine hydrogen dioxide, fluorine carbonate. So what I'll do is, suppose I'll patent fluorine after 20 years, just to extend my patent. It's something called as evergreening. Okay, so after 20 years, I try to keep the patent flowing for a long period of time. So after 20 years, I'll take fluorine and I'll say hydrofluorine. Okay, give me patent on hydrofluorine. So in effect, I'm pretty much patenting the same thing. It's just I'm using a new form of the same substance. I'm using a salt version of that chemical, or I'm using an ester of that chemical, or I'm using some the pure atomic the ionic form of that substance and getting a patent on it. Okay, so India does not allow any of this. Any new form of a known substance which has no increase in efficacy. Suppose I can prove that this carbonate form or this ester form or this salt form gives a new kind of efficacy. Now the efficiency has improved, there's some form of technical advancement. Unless I can prove that, a new form of a known substance is not patentable. Okay, similarly, a new use of a known product or process also not patentable. Okay, like I said, mefloquine, even though if I come up with a new solution tomorrow, I cannot use it for treatment. Okay, another example would be like aspirin, the headache tablet that we take. So of course it cures headaches, but after a while the company owners came and said that, you know what, it also can be used for the cure of diabetes. It helps to control blood sugar levels, right? So maybe US might allow it, but India will never allow it. Okay, so there's a landmark case on this, Novartis versus Union of India, Indian case. So in this, what happened was there was a treatment, some form of cancer treatment drug by Novartis. Novartis is a pharmacy giant. Okay, so what they did was, once their patent expired, they formed a new form of it, new form of the chemical. They brought some new kind of salt version of it, imatinib mithosulfate, something like that, the chemical name. So they said that this new form that we have brought has a lot more absorption. It's slightly more efficacious. So it's better you give us a patent on this now. Okay, so the Supreme Court struck it down. They said nothing doing. Section 3D says that no new form of a known substance is allowed. And even if you're going to show us some form of increase in efficacy, even if your efficiency is increasing, prove it to us. Show us that there is a therapeutic efficacy. Okay, show us that humans are benefiting now. Show us that humans are able to better recover from this disease now. Okay, so it's a landmark case on section 3D. So how you'll remember D is D for drugs, any new form of a known substance or a new use of a known drug. Okay, 3D. Then any doubts from A to D? Cool.
Just
Just
one
listen
doubt.
to it. Go on, go on.
So suppose we have got the natural a phenomenon like superconductivity. So
Hmm?
which will give you infinite current, and infinite current will also lead to infinite magnetic field. Now this also becomes contrary to natural laws, but there are also researches going on for the same. So can they give patents to the materials which can help you realize these natural phenomenon?
Yeah. So superconductivity as a phenomenon. Suppose you have discovered that superconductivity exists. This is not a patent. Okay. But suppose you conduct and synthesize a new form of metal. You only combine some alloys. You use aluminium, nickel, this, that. You combine your alloys in a certain way and you develop a new form of superconducting material which can conduct at a superconductor level. Then that is patentable. Okay.
Oh,
Because what you have created is your own creation. It's an invention. It's not a discovery of a scientific principle. You have not discovered anything. You have invented it. Okay.
okay. No,
That's
not
about it.
that,
Cool.
because you said anti-gravity medicines. Now this becomes contrary to
Mhm.
natural law.
Oh, right. So superconductivity is not contrary to natural laws, right? This is something that we accept. So
Okay.
contrary to natural laws would be something absurd. Like let's say I'm bringing back my grandfather's uncle from death now. I've
Okay.
invented a machine to bring back people from the dead, right? So it's frivolous and it's contrary to natural laws. Or
Okay.
let's say I file a patent for a time machine. It'll let you go back in time, right?
Mm.
Nobody's going to give you a patent on that.
Okay.
Cool. Okay. So A, B, C, D, you remember as absurd, bad, speed of light because the symbol C, and then D for drugs. Cool. And then,
Uh,
yeah. Any other question?
isn't the clause be harmful to the defense industry because they are developing like new kind of weapons? So, but they
Right.
can't.
So this also you'll study in next week's meet. Anything that is related to defense will not be allowed to patent. Okay. Any kind of bomb, anything that which is affecting the sovereignty and security of India, the defense of the the territorial integrity of India, the defense of India, all these are not patentable. Okay. Any gun, any bulletproof jacket, any bomb, any missile, nothing is patentable. Okay. So of course, if DRDO develops it, they are not getting a patent on it because they're not going to sell it to everyone, right? They're going to keep it secret. It's all top secret, right? So these are not patentable. Cool. Apart from that, A, B, C, D are done. Now E to I. So any mere admixture resulting only in the aggregation of the properties. The simplest way to understand this is you take katta meeta, you take Punjabi tadka, and you mix all of it. Okay. Or you take red lace and you take green lace and you mix it and then you eat it. Right. Do you create a new dish now? No. You still have a mixture with the known properties of katta meeta and Punjabi tadka. You still have the same taste of red lace and green lace, right? When I take a piece of the red lace, it'll taste like red lace. When I take a piece of the green lace, it'll take as green lace, right? So just a mere admixture, just me mixing two different things, which is just going to combine the properties. That's not a patentable invention, right? Okay. So this is a patent killer for all the chemical inventions. So a lot of chemical inventions where you combine this and that, if it's just a mere admixture, it'll kill the chemical invention. Okay. So how you
Okay,
remember this is, yeah, just a second. I'll take doubts at the end of this section. Okay. So E stands for eat, right? Eating any mixture. So eating Punjabi tadka, eating katta meeta. That's how you remember E. Mere admixture. Okay. F is mere arrangement or rearrangement of any known devices. Okay. So what it means is, suppose I have a computer and I have a printer with it. Okay. Suppose I combine 3 or 4 or 5 printers now with it. Now it's printing at 5 times the speed because it has 5 printers. My phone has one camera, right, at the back. Now I install 8 cameras, like how all the companies are doing now. Do you think these are all patentable? Suppose I add more cameras now. Okay. Suppose I take my coffee table and I add a camera on that. Okay. Suppose I take my TV and I put a camera on that, or I put some voice recorder on that. So what am I doing? I'm just combining already known existing devices into the same device now, right? I'm combining different devices into a single device. So mere arrangement or rearrangement or duplication of known devices which function independently in known ways. This is not patentable at all. Okay. So combining 5 printers together so that now I have 5 times the printing speed. Firstly, it doesn't have an inventive step, right? It's something which is very obvious. So it fails the inventive step test there itself. And secondly, There's a case also which happened, LML versus Bajaj. So Bajaj had a new form of engine system. Okay, so they rearranged the components in an engine. Okay, they moved the piston a bit, they moved the injection valves a little bit, just slight adjustments, and they got an increase in efficiency. Okay, so LML is the company which owns Vespa. So they challenged, and Bajaj got a patent on this slight rearrangement. So LML said, according to Section 3F, Bajaj cannot get a patent on this, right? So why did you guys give the patent on it? So patent office said, what Bajaj has done, it's not a mere arrangement or rearrangement. When they rearranged it, there was a lesser fuel consumption, and a lesser uh, emission now, right? So what they said was, the engine has become more efficient because of this arrangement. It's not just a mere arrangement or a rearrangement. It has resulted in an increase in efficiency of the engine itself, right? So the patent was granted. So technically, Section 3F, F is usually the patent killer. Most of the patent inventions, the machines, the products can get killed under 3F. Okay. Then section, how you remember this F is 5 printers. I gave an example of 5 printers, right? So F5, so 5 printers, remember as F. Okay. Section 3G has been removed, not there anymore in the Patents Act. Section 3H is very easy to remember. Any method of horticulture or agriculture. Horticulture means any method of growing fruits or vegetables, right? Agriculture is growing of crops, rice, wheat, maize, corn, stuff like that. So why do you think this is not allowed? Like I told you, it's a matter of public policy. India being a developing country, we do not want to hand out patents on anything which might harm our food security in the future. Okay. Suppose I invent a new method of growing rice, or some form of new variety of rice which gives a larger yield. As in, like, per hectare, I get 10 times the yield now because of my seed now, the kind of gene I've developed for the rice variety that I've made. Even that is not allowed now, right? Any method of horticulture or agriculture as a result of public policy is not allowed in India. So H for horticulture, that's how you remember it. I is any surgical, medical, curative, diagnostic treatment of humans or animals. Okay. Any medical treatment that I create for any human or any animal, this is not allowed to be patented. Let's say I invent a new form of cancer treatment. Okay. Or any new method of diagnosing cancer, or detecting cancer, or diagnosing HIV, right? So all this is not allowed to be patented. Okay. Understand the crucial difference here. I'm talking about treatments. Okay. Not medicines. Medicines you can still get a patent on, but treatments you cannot get a patent on these. Okay. So any form of surgery, suppose I find a new way of conducting brain surgery, this is not patentable. Again, why this is not allowed is purely for public policy concerns. They do not want to give any form of patents on anything which allows anything which affects human health. Okay. So this sort of combines with 3B also, where 3B also talks about prejudicial to human life, right? So don't you think giving a patent on any form of surgical treatment, or a curative treatment, or a diagnostic treatment, diagnosis means identifying a disease. Suppose you give a patent on even identifying a disease, don't you think this is prejudicial to human life? Right? It's not accessible to all the people now, right? So as a matter of public policy, surgical, medical, curative, diagnostic treatments, these are not allowed patents. Okay. But it does not include medicine. Suppose I invent a new form of cough syrup, this I can get a patent on. It's just the treatment of it. Okay. How you remember it is, what do you get in treatment? First thing, you get an injection, right? I for injection. That's how you remember it. Okay. So any doubts in these 5? Somebody had asked, right? Somebody had unmuted to ask a question. Cool. I'll be moving on. So how you remember it is? Yeah, go on, go on.
Yeah, actually, I was asking in E part,
Hmm?
if the properties of the both the chemicals we are mixing, if the property get changed, though, so I think we will be able to get the with
What is
this.
what you're saying is spot on. Okay. So if you guys drink, there's a cocktail called a Jägermeister bomb. Okay. A Jaeger bomb. So they take Jägermeister and they mix it with Red Bull. Okay. So how they give this is, they give you a glass filled with Jägermeister. They give you a glass filled with Red Bull. Okay. So the Red Bull is pink in color. Inside this glass, they have a little bit of Jägermeister. They invert a shot glass inside and they keep it. So the Jägermeister is purple in color, and the Red Bull is slightly pinkish in color, dark purple and slight light pink. And when you lift the shot glass, it turns green. Okay. I know it's a very absurd example to give, but yeah, what he said was right. If you can combine two things to give a certain different property itself, because Red Bull is a caffeinated product, right? It's something that wakes you up, while alcohol is a depressant. It makes you fall asleep, right? But when you combine both, you get an alcoholic beverage, right? So if you can combine the properties of two different substances, and you don't get just a mere admixture. So if I combine Khatta Meetha and Punjabi Tadka, and let's say I sit for 7 hours, don't you think it's possible for me to pick it out and separate the Punjabi Tadka and Khatta Meetha again? Right? In which case, there was no true mixture that I've created here in the first place. Right? I can individually identify the components based on what I eat. If I eat a piece of Punjabi Tadka, I'll know it's Punjabi Tadka now. Right? So we're not talking about mere admixtures, but of course, if you combine two chemicals and you get a greater property, right? Same thing which happened in 3F, where Bajaj combined the same engine, it just rearranged it a bit, but it ended up getting a larger efficiency, lesser fuel consumption, and lower emissions. So in which case, it was not a mere arrangement, right? If you can show an increase in efficacy or efficiency, then it is patentable. Only a mere admixture. Note the word mere. Okay. Apart from that, moving on. So how you remember this is eat mixture, you eat mixture, right? E, 5 printers, F, horticulture, H, I, injection. Cool. Then the last set, J for plants. Okay. So any plants and animals are not patentable. Can I take my dog to the patent office and say, give me a patent on this? Of course not, right? Dogs, cats, bananas, capsicum, California Reaper chili. I'll explain that a little later. But in general, anything which you can find in nature, right? My dog, my cat, my hibiscus plant, a Venus flytrap, these you cannot patent. Okay. And you not just the plant, as in not just the plant which I dig up from the ground, even the seed of the plant, any variety of the plant, any cross species of that plant, you can't patent these things. Okay. I can't take a seed and say, oh look, it's not a plant, the seed will come later, the plant will come later, so you patent the seed. Even that is not allowed. Okay. So don't you think, haven't you heard of these people who do some kind of genetic modification to the plants? GMO, genetically modified brinjal, genetically modified cotton, genetically modified chilies. So California Reaper chili is a genetically modified chili. So it's a chili which is extremely spicy, right? So I told you anything which is directly found in nature is not patentable, right? But if you have some form of man-made element to it, where you yourself do some kind of alteration to it, right? Then in that case, it is protectable. Okay. In this case, it is protected under the PPV Act, the Protection of Plant Varieties Act, not under the Patents Act. Okay. But it is protected. Even genetically modified brinjal, genetically modified cotton, all this is protected, but not under the Patents Act. It's protected under the Protection of Plant Varieties and Farmers' Rights Act. Okay. So it's protected under a separate legislation. So how you remember this is J for jungle, and jungle you have a lot of plants and animals. So J, not patentable. Okay. Then K is mathematical or business method or any computer program per se or algorithms. Okay. 3K is the most important part of this section. Just pay attention here. It has 3 parts. Firstly is mathematical or business method. Second is computer program per se. And third is algorithms. Every word is important. Okay. When I say computer programs per se, remember that per se also. Okay. So as of now, we don't have to dive very in depth into it. You'll study this in depth in your second year of law. So don't worry too much about it. In general, what I'm talking about is when I say mathematical or business method, let's say I invent a new method of predicting stocks in the stock market and some new form of hedging risks. Okay. Suppose you use my method, you're going to end up getting the best profits, lowest risk, and highest gains. Okay. Do you think this is patentable? Okay. So this is again very contentious. 3K is a very contentious provision because US allows mathematical and business methods and it also allows computer programs, while India allows computer programs also very hesitatingly, but it does not at all allow mathematical methods. Okay. So again, don't break your head too much over this. In general, any mathematical method, suppose I've invented a new form of calculus. Okay. Any new form of integration of multivariable calculus, some new form of multivariable calculus, not patentable. Okay. Any business method, any way of allocating risks, any form of buying stocks, predicting hedging risks, all this not patentable. Okay. New form of calculus, not patentable. Can I get a patent on WhatsApp? Again, it's a little complicated. A computer program per se is not patentable, or even algorithms are not patentable, but they have started allowing patents. It's a little complicated. Let's discuss this on another day. But in general, these are not patentable. Okay. Any mathematical or business method, any computer program, or any algorithm, not patentable at all. Okay. How you remember this is computers, but computers with a K. Okay. So section 3K is computers related, algorithm related, any business or mathematical method. Okay. 3L is very simple. Suppose I shoot a movie or I write a storybook. Can I get a patent on this? No. Why? Because all these are protected under copyright. Okay. So they have a separate legislation for it. Like how the California Reaper chili is protected under the Plant Protection Act. In this case, all these are protected under the Copyright Act. Okay. So any literary, dramatic, musical or artistic work or any cinematographic work, all this is protected under copyright. Okay. How you remember this? Very simple. L for literary. So L for literary, it starts off, the provision itself starts with L. So that's how you remember L. Then M is any mere scheme or rule or method of performing a mental act or a method of playing a game. So all this is rubbish, okay? So they've literally run out of things to write. So they've just written all the absurd rubbish at the end. So very simple. Suppose the rules of cricket, can you get a patent on this? Or the rules of football, can you get a patent on this? Or let's say I develop a way of memorizing phone numbers, okay? Some new method of memorizing names and phone numbers. Can you get a patent on this? No. So any method of performing a mental act, such as memorization, or some kind of rule of playing a game, or any form of new form of scheme, all this is not patentable at all. Okay. So M for mental act, M for method. So 3M is mere scheme or method of performing a mental act. Okay. Last three, and then I'll take doubts. So section 3N is news. Okay. Think of NDTV. Okay. A presentation of information is not patentable. So how I presented all this in a PPT now, how I presented it, as in the order of the slides, what kind of text I've used, the font I've used, all this is not at all patentable. Firstly, it's copyrightable. It's protected under the Copyright Act, but not as a patent. Okay. So presentation of information, as in news, this is not patentable. Cool. So O is topography of integrated circuits. Again, how you remember this is topography. So there's O, right? Topography of an integrated circuit. So integrated circuit is when you break your washing machine, you'll see the IC chip, right? That green colored breadboard with all the resistors, this thing, all the solenoids and all that soldering done on it. That's the IC circuit. Okay. So why is it not patent protected? Because it's protected under a separate act. It's protected under the semiconductors and the integrated circuit layout design act. Okay. There's a separate act itself for it. It's not protected under patents. Okay. And lastly, traditional knowledge. So what your dadi taught you, what your dadaji taught you, do you think you can get a patent on it? Why? Because all this is already in the public domain, right? So what the US did was in 2000 they tried to patent turmeric. Okay. All the wound healing properties of turmeric, the US tried to patent it. Okay. And India challenged it, and the patent was refused because turmeric's wound healing properties are a part of India's traditional knowledge, right? So there's a lot of traditional knowledge in the world. There's also a traditional knowledge repository where you can actually go and check if your patent is a part of that or your invention is a part of that. Because you know, right, everything will fall somewhere. Somebody's grandmother would have said something, somebody's grandfather in Russia would have taught something. So a lot of these properties already exist. Okay. So this is about it for section 3. And the last thing, section 4 only talks about one thing. Inventions relating to atomic energy are not patentable. Suppose I invent a new form of atomic bomb in my room, or I invent a new form of nuclear reactor, or I invent a new atomic clock. All these are not patentable. Anything related to the atom or any form of nuclear energy are not at all patentable under section 4. Okay. So section 3 and 4 are done. Any doubts?
Just one doubt. Can you go to the in the inventions, not this one, the previous slide?
Huh?
There's one case which you said that LML versus Bajaj.
Hmm.
There's one more case, right? Bajaj versus TVS, and are you going to cover that part because patent was not granted to I think Bajaj I think in 2008 or 9. Do you have any idea?
Bajaj versus TVS is not relevant to this section, but Bajaj won the case.
Okay.
Again, it's not connected to the sections. Okay.
Okay,
So
okay.
the cases I'll introduce here are only those related to the provisions itself.
Okay.
Cool. That's
Yeah.
about it. Okay. It sounds like a lot to take, but it's very simple. Very easy. A, B, C, D, E, F, G, H till P. Okay. A for absurd, B for bad, C for speed of light, D for drugs, E for eating mixture, five printers, H for horticulture, I for injection, J for jungle, K for computers, L for literary, M for mental act or method, and N for news, T for topography, P for parents. Okay, because your parents are the ones who teach you traditional knowledge, right? Your party will come and explain to you, Dadi, Pardada, stuff like that. Okay, atomic energy, that you'll be able to remember because it's only one section. Okay. Okay, so that's it. We finished the basic concepts. Now we'll cover the procedural aspects in the next half. Take a 5-minute break and then come back. Okay.
अरे कोई है कि चले गए सब?
हम्म
क्या? अच्छा अच्छा, हो आप सही है तब तो।
हम भी हैं।
हम भी है। कैसे हो
कैसे हो
राहुल?
राहुल?
बढ़िया बढ़िया भाई।
क्या कर
क्या
रहे हो?
कर रहे हो?
बस रजाई में घुसे हुए हैं भाई।
नहीं,
नहीं,
इंटर्नशिप
इंटर्नशिप
कहाँ कर रहे
कहाँ
हो?
कर रहे हो?
क्या 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 किस चीज का भाई?
इंटर्नशिप।
इंटर्नशिप।
यार गए थे इंटर्नशिप, लेकिन कुछ समझ में नहीं आया अभी तो।
या
या
सिविल या
सिविल या
क्रिमिनल?
मैं मैं गया था सीधे उसमें टाडा वाले में। एक को टाडा दिलाना था।
टाडा
टाडा?
वो क्या है?
वो क्या है?
अरे वो होता नहीं है उसमें इलीगल गन्स रखते हैं, तो आतंकवादी वाले केस में गया था मैं। एक के ऊपर चल रहा है।
लिटरली।
संजय दत्त। संजय दत्त।
संजय दत्त वाला सीन वही वैसे ही। उसने देसी कट्टा रखा था, उसके ऊपर टाडा लगा दिया। अब पुलिस वाले कह रहे इसके इसको AK-47 पकड़ाओ, तब इसको हम लोग प्रूव कर पाएंगे।
बढ़िया है।
बढ़िया है तो।
हाँ, बहुत कुछ सीखने को मिला। हमने ये सीखा कि देसी कट्टे से गोली नहीं चलती है।
आपके
आपके
क्रिमिनल थे?
क्रिमिनल थे? उत्तम भाई थे। कट्टा उत्तम भाई चला रहे थे।
Chalo, how's it going, guys? How's it going? Focused? Is it too much?
No, it's going really good.
Problem is, you don't have a proper explanation anywhere for all this. Like even I struggled a lot when I studied it first time. Right. So we're almost done. So be a little more energetic. We'll finish off. Right.
It's going good.
Mhm.
It's actually going good.
How's the subject?
Now it's going good, but initially when we were referring the barrack, and it was bouncing from me. It was like it is written in Hebrew language.
Yeah, yeah.
Yeah, yeah.
We find the barrack very, unoriented. It is not oriented well.
Yeah, yeah. But yeah, once you understand the concepts now when you read the Bare Act, it'll be very clear. Cool. Is everyone back? I think we'll keep going. What is this? No inventive step. Oh, Roni is replying. I'm so sorry. I didn't see this. Any doubts, Roni?
Actually, I have a question,
Go on,
but
go on.
it is means absurd question.
Huh.
But can anybody file a patent on any religion, like he invented a religion or a gender?
Two reasons. You should only be able to tell me which provision it would be. Firstly, section 3B, it goes against public order and morality. Correct? No, it will create fights and all this. So government will never allow it. And secondly, it goes under 3A also. It's something that is frivolous, right? Or contrary to you can't call it contrary to natural laws. It's frivolous. Religion, interesting. What do you think you can protect religion under? I think you can protect it under copyright. As in, like, suppose I write a religious text. Let's say I was a person who wrote Bhagavad Gita. You can get copyright protection on that, but not a patent on it. Okay. So patent itself means something technical. I told you, right? It has to be a product or a process. Can't be a religion. Can't be like a Gmeat, stuff like that.
Okay.
Cool. Let's proceed then. Wait, I'll just turn on my camera. Cool. Unfortunately, we could not record today. I tried a lot, but wait. Okay, is my screen visible again?
Yes.
I'll keep a pointer also this time. Cool. All right. So we've already understood what are patents, what things are eligible for patent protection, products and processes. What is the test that you use to determine is it patentable or not? Somebody is unmuted. Can you mute yourself? Right. So what is the test? Novelty, inventive step, industrial capability. After that, we also saw what are the inventions which are not patentable. Okay. Even if they satisfy novelty, inventive step, Government of India does not give patents on these kinds of things. Okay. Atomic bombs, nuclear reactors, anything which is frivolous, contrary to prejudicial to human life, surgical treatments, all these are not patentable. Okay. Now, who can apply for a patent? Let's say there's a invention, there's a new kind of mobile phone. Who can go and apply? Can I go and apply for Samsung mobile phone? No. Okay. So only three people can go and apply. Firstly, the true and the first inventor. Secondly, an assignee of the true and the first inventor. And lastly, the legal representative of either the true and the first inventor or the assignee upon their death. Okay. So true and first inventor is who? The person who invented the thing, right? The person who invented the invention. Of course, he can always go and apply. Secondly is assignee of the true and first inventor. So assignee would be someone to whom you transfer all the rights of the invention to. Okay. So let's say you guys join as IP lawyers for Bajaj. Okay. As long as you guys are working over there, although you will be the ones inventing, let's say you are working in the R&D, you invent a new form of engine, you will be the true and first inventor. Okay. But because of the contract of employment, all the things that you invent will be automatically assigned to Bajaj. Okay. So Bajaj will be the assignee by default, whatever you invent in the course of your employment. Okay. Of course, if you come home and you invent something completely unrelated, Bajaj won't have a control over it. But anything that you invent related to motorbikes using Bajaj's facilities, they will be the assignee by default. Okay. So assignee can also be your friend. Suppose I invent something, I make Satyanarayan my assignee. Okay. So he can also go and apply on our behalf. Okay. So in this case, Doraemon invented the bamboo copter, so he can go and apply. Next, Nobita, since by virtue of being his best friend, is also the assignee, assuming Doraemon and Nobita have a healthy relationship. And in case something unfortunate happens and both of them die, then what happens? Then the legal representative of either A or B can go and apply for the patent itself. Okay. Again, this is assuming that Nobita marries Shizuka. No comments on that. Uh, Next, the second thing is section 7 talks about what all do you submit with your application. Okay. Firstly, can you file an application for multiple inventions? Suppose can I file one application for a laptop, a TV, a massage chair, a car? No, you can file only one application for one invention. Okay. Every application should have only one invention. Secondly, when we talk about the international applications, okay, there are certain requirements. What all documents you have to submit? We'll discuss it next meet. So it's called as a PCT application. PCT is Patent Cooperation Treaty Application. So you'll always see PCT application or you'll see convention application. So when I go through PCT treaty, it'll be called as a PCT application. When I go through Paris Convention, it'll be called as a convention application. So convention application and international application you'll see multiple times in the Patents Act. Till 6 months into reading patents, I never understood what they were. I'll explain it to you next meet. Okay. So these also have to be submitted. Suppose you're filing an application in European Union, there are certain requirements that you'll have to comply with, right? You'll have to submit certain proofs. Next, suppose Nobita goes to apply for the patent, and the patent office like, how do we know you're the assignee? What if Doraemon has given it to someone else, right? So in which case, Nobita will have to give the proof, right? The proof of assignment. He'll have to furnish it to the patent office. Next, let's say Doraemon only goes. And how will Doraemon prove that he's the true and first inventor? He'll have to give an affidavit. Okay. So a declaration of him being the true and first inventor, saying that whatever I've stated is true to my best knowledge and ability. In case something happens in the future, you can put me in jail. Okay. If somebody else comes and says they are the true and first inventor. So the affidavit will be binding on you. Okay. And lastly, and the most important thing, the provisional or the complete specifications. Okay. Something very important to understand, because don't you think when you file a patent you have to give information on how the patent works, right? This is called as the specifications of the patent. Every detail about the patent, all the diagrams, all the data, all the experimental results that you have got, all the features of your invention, all the ways to apply it, all the uses of your invention, all this has to come in the complete specifications. Okay. It's either the provisional or the complete specifications. I'll explain the difference now. So it's basically the complete technical information of your invention. So when you guys learn patent drafting in meet number 3, you will learn how to draft the complete specifications, right? Suppose the inventor who comes to an IP lawyer, he'll tell you, I've invented this mobile phone, right? It's your job to sit and draft these complete specifications to make them properly procedurally compliable for the patent office, right? It has to be legally binding. That's why it's very important to make these complete specifications properly. So these also you have to submit with your application, right? So there's somebody called as a controller, right? So a controller is like the end all be all for patents. He's like the supreme commander king. He's the lord. Okay. If the controller decides he can screw you, if the controller decides he'll grant you a patent. Okay. So for India, there's one controller, the Controller General of Patents, Designs and Trademarks, India. Okay. So he is in charge of all the patents, designs and trademark applications which come in India. So in India last year itself, 30,000 patents were granted. Okay. Do you think it's possible for one controller to read 30,000 patent applications? right? It's not possible. Since this meeting is not recorded, it's possible only if you're like KD Raju sir or if you're Superman, but it's not possible for one person to read so many applications, correct? So there is only one controller general, but there are hundreds and hundreds and hundreds of assistant controllers, okay? Assistant controllers, additional controllers, and then some associate controllers. So they pretty much, there are a lot of controllers, but for the namesake, there's only one controller according to the act, okay? All the requests that you have to make, any application that you want to submit, any submission, any form, any details that you have to give regarding your invention, everything has to be made to the controller, okay? Suppose you're even saying that you're going to withdraw your application, even that you'll have to submit to the controller. It'll have to be addressed to the controller general of India and then address it to the patent office. Cool. And the controller powers, the powers of the controller are listed in a lot of sections. You can just read through them. But basically, the controller has the same powers of a judge. Okay, he can summon witnesses, he can take evidence on oath, he can conduct hearings, he can award damages, stuff like this. Okay, so pretty much very powerful guy. He's a controller. He controls all the patents. Okay, so that's why he's called as a controller. So everywhere throughout the Patents Act, you'll keep seeing if the controller is satisfied, if the controller considers it necessary, if the controller so desires, the controller may order. Right. So the controller is like the king. Cool. So now we're going to discuss a few concepts. Like first you saw what is the controller, right? Now we're going to see what is a priority date. Okay. So priority date is the date of your patent. As in, suppose I have a mobile phone, right? The day I go and file the application for this new mobile phone that I've invented, that will be the date of the patent, and that will be the priority date. Okay. So it is the date of claiming the invention. On this date, the invention must be novel, inventive, and capable of industrial application. Like I told you, after this date, any research paper that comes up, any other invention that comes up, totally fine. But as of that date, as of the date of filing, as of that priority date, it has to be new. It has to have an inventive step. It has to be capable of industrial application. Okay. And your invention's protection starts from this date. I told you, right? The duration of the patent starts from the priority date, the date of the patent. You have 20 years of protection from this date. Okay. So how it works is, pay attention. I will go very slowly. Okay. Let's say on June 1st, 2023, I file my patent application for a new pair of shoes. Okay, it's a lightweight shoes which will help you run faster. Okay, so on 1st June 2023, I filed the patent application. Automatically, 1st June became my priority date. Okay, and from 1st June, just one second. From 1st June, you can already see the end where the patent dies. The death of the patent happens on 1st June 2043, which means you have 20 days, 20 years, okay, between the priority date and the death of the patent. So from the priority date, after that, a lot of things come into play now. You'll see that now in the procedural aspects. After that, the patent office will engage in the processing of the patent. This might range between 6 months to 3 years. And after that, let's assume you get your patent in 2025. 30th May 2025, you have the patent granted to you. Okay. From the date of the grant, you can completely exploit it for the next whatever time you get. I think we have around 10 plus 8, 18 years left to completely exploit the patent. Okay. Where you can license it to other people, you can assign it to other people, you can use it to stop infringement from other people from the date of the grant. Okay. But sometimes you might ask me, oh, what if the patent office takes 8 years? Suppose you patent office takes 9 years. Okay. What happens in that case? So I told you guys, right? There was a case in 2019, Farid Alani versus Union of India. It was the patent case where the Delhi High Court allowed software patents in India. Okay. So in that case, the patent was filed in 1999. Okay. The priority date was 1999. And in the end, the grant happened in 2021. Okay. 21 years after 22 years after the patent was filed, the patent was granted. So when the patent was granted, it was already dead. Okay. So this buzzard happens in India. You know, right, how our government offices function. So no matter how much time this thing takes, you'll still have to go by process and you'll have to wait for the grant of the patent. Okay. I know sometimes the grant might happen just 1 year before the death of the patent. You're pretty screwed. But what do I say? Pretty much the patent office tries to get it over as fast as possible. But even then, even if the patent office has taken so much of time, it's because there is some issues with your invention, right? For no reason, they will not extend and delay it. There will be some reason for the delay itself. Okay. Somebody will be opposing it, or maybe it doesn't satisfy the novelty requirement, or maybe COVID hit for like 5 years and there was a lockdown for like 6 years, stuff like that. Okay. So this is in general the timeline of a patent application. So you can notice 20 years from the date of priority to the death of the patent, right? Next, with respect to priority date, just a quick example so that you understand the concept perfectly now. Let's say Doraemon has filed the application for Bamboo Copter on June 1st, 2023. Okay, he's got the priority date. After June 1st, baad mein jao, anybody files or writes a research paper, any TV show comes talking about bamboo copter, I don't care. June 1st, my invention is novel, I have my patent. Okay. So the patent application has been filed on June 1st. Let's say on July 1st, 2023, Sunyo files a patent application for the same thing, for a bamboo copter application. Okay. What do you think? Who has the priority in this case? In this case, Doraemon will have the priority because his invention was of an earlier date. Okay. So in which case, when Sunyo files his application, his invention fails novelty now because his invention has already been anticipated by Doraemon's application. Okay. Since this was earlier, Sunyo does not get priority. Doraemon still has the priority date. Okay. Let's assume on Feb 1st, 2023, 3 months before Doraemon itself, a bamboo copter research paper has been published by this rascal Digisuki. Okay. So now Digisuki has already published a research paper in February only, in which case Doraemon's bamboo copter application would have been anticipated in February itself. The priority belongs to Digisuki now, right? So if Digisuki chooses to file an application, it's self anticipation, right? Because he has published his own paper. If he chooses to apply for a patent himself within 12 months, he can do so. So as of now, Doraemon has lost his priority date. The priority date has gone to Feb 1st now. Okay, so Doraemon will never get his patent. The patent office will eat up 5 years of his time, spend up litigation fees, this, that, but he'll never get his patent now. Okay, because the invention has already been anticipated in a research paper. Cool. So what ends up happening is a lot of these huge companies are in a race now. Okay, because they want to get their invention first, right? They want to get their patents first. So sometimes I realize that Subramaniam's company is doing faster R&D, so they'll end up getting the research done faster. They'll get the patent on this, and I'm going to be screwed now, right? So what will I do now? Just to sabotage Subramaniam's company, I published a research paper today. Okay, just about the technology, just to put hurdles in his path to get a patent on his invention, right? Because if I publish a research paper today and he files for the patent after next week or even tomorrow itself, right? In which case, my research paper has already anticipated his technology, right? So this is what companies do. They do defensive publications. So they publish just to sabotage other companies, just to make sure that Apple cannot release some new form of touchscreen technology. Samsung will release hundreds of research papers on it, just to make sure that Apple will not have novelty on its technology when it goes for a patent. Okay, so this is how it's offensively used. Okay, I think priority date is very clear. Now, I spoke about two things, right? When you submit your patent application, you will have to submit the specifications. So you have provisional specifications and you have complete specifications, right? So firstly, what is provisional specifications? Provisional itself means what? Provisional, as in temporary. Okay, so temporary means, like I told you, there's a race, right? Sometimes your invention is not fully ready. Suppose I have to file today. I have to file on June 1st, 2023, but my invention is not completely ready. I still am developing it. Okay, the invention will slightly get modified. There'll be slight improvements. There'll be slight changes, but I still want to file it now because I want to prevent Digisuki from writing a research paper tomorrow. Okay, so I'll still file it today only. So the application, although the invention is not fully ready on the date of the filing, the application is filed early in order to fix the priority date, just to secure that red flag, just so that I can put up that red flag on that date. I'll end up filing my application earlier when my invention is not fully ready. Okay, but the complete specifications will have to be filed within 12 months. So I have a 12-month timer now. So I've given the provisional specifications. Within 12 months, I'll have to give the complete details and data regarding the invention. Okay. If I don't do that, if I fail to do so in 12 months, my application will be deemed abandoned. Okay. With a provisional application, with provisional specifications, an application will not be processed. The patent office will take it and throw it in the dustbin. Okay. So a simple example of this, we'll go very slowly. So June 1st, 2023, I filed the application for bamboo copter. Okay. Since I have to prevent anyone else from stepping in, even though my invention was not fully ready, I file it with provisional specifications. Okay. And then till 1 year, okay, till June 1st, 2024, technically one day before, so 31st May 2024. So let's say 1 year from now is the deadline for filing the complete specifications. Only if I file it within that 1 year, if filed, only then the processing continues and then the patent office will process your application. If you don't file, your application will be deemed abandoned, it will be thrown in the dustbin, and you will never get your patent granted. Okay, so these are provisional specs. Some additional things to know about provisional specs. So somebody has posted a message. Wait, I'll take it out right after this. So let's say I've invented a massage chair, okay? And let's say I've invented a massage chair also with certain modifications. I've attached a TV to it and I've attached some additional vibration for the neck over here. Okay. And it's the same applicant. I've invented both of these chairs. But I already told you under section 7 that per application I can file only for one invention, right? So can I file an application for both these inventions in one? can I file an application for both these inventions in one form? I can't, right? I'll have to file separate applications. Okay. So let's say I file the application for this massage chair on June 1st, 2023. And I file the application for this massage chair on June 5th. Just 4 days later, I file it for this chair. Okay. So I file provisional only for both. I file provisional application for this, provisional specifications for this. So now I have 1 year time, right, to file complete specifications. Since both these inventions are very similar to each other, right? They both are cognates of each other. As in, one is just a modification of the other. In this case, the controller, you remember this guy, right? This controller, if he will allow me to file just one complete specification in respect of both these inventions. Okay. Since I'll be explaining the same technology for this massage chair and that massage chair. Basically, the variation is only a small thing. Basically, one extra vibration area and one extra TV. Pretty much the complete specifications will be the same thing, right? So in this case, the controller, if he is satisfied, then he will allow you to file only one complete specification in respect of all the provisional specifications. Okay. But this is possible only if the two or more applications of the inventions which are cognate or modifications of each other. Okay. Very simple. After this, let's say if the complete specifications has been filed with the application, as in like, let's say Doraemon is very scared now. Okay. He's very scared of anybody else coming in. And on the date of filing the filing the application itself, he's like, look, I want no buzzard. I'm going to file the complete itself on this date only. On 1st June 2023 only, I file even the complete specifications. Totally safe, no? Cool, all cool. And then once you file the complete specifications on June 1st itself, then he realizes, oh, damn, I made a mistake. Like, what if I modify this? Suppose I had added something extra, my bamboo copter would have been much better now, right? So you make slight modifications after that. But what can you do now, right? Because your complete specifications have already been filed. So what can you do? You can request the controller to change your complete into provisional, and then you can make the modifications and then file the final complete specifications at the end. Okay. So that's the next provision. So if the controller is satisfied, the second provision is if a complete specification has been filed with the application itself, then if the applicant requests before 12 months of the filing, then the controller may convert it to a provisional specification. As in, your complete will be made into a provisional, then you can make a modification and then you can file the complete again at the end of it. Okay. And then the last power which the controller has is the controller may cancel the provisional specifications and allow post dating of an application. Okay. I'll explain to you what is post dating now. Okay. So post dating is, let's say you have a 12-month requirement, right? Once you file your application, you have 12 months to file the complete specifications. You file your application, you file it with the provisional. Now you have 12 months to file the complete. Okay. Let's say it has become November now. 11 months have passed by. 11 months and 20 days have gone by. You have only 10 days left. So now what's going to happen now? There's no time now, right? In 10 days, you can't literally think of new things to add. You can't completely file the complete specifications in 10 more days. So what can you do? You can do something called as post dating. Okay. So an application may be post dated by 6 months, as in like you can grant yourself 6 months extra. Okay. You can grant yourself 6 months extra, which extends the deadline for filing the complete specs by up to 6 months. But in doing so, you lose your priority date by also up to 6 months. Okay. It's not 6 months, by up to 6 months, maximum 6 months, you can get it extended. So firstly, it gives you the benefit of extending your deadline by up to 6 months. But the disadvantage is you lose your priority date also by the amount of extension. Okay. So it gives you more breathing space, but at the risk of losing priority. So a very easy to understand example would be June 1st, 2023, you file your application with the provisional specs. Okay. And then on June 1st, 2024 is the deadline for filing your complete specs, right? You get 1 year time to file the complete specs. But then you find out that 2 days left and you don't have enough time. So you request the controller to post date your application. So he post dates it by a max of 6 months. So now your new deadline for filing the complete specifications is June 1st plus 6 months. So that is 31st December, because it's Jan 1st, 1 day before. So 31st December 2024 is your new deadline for filing the complete specs. And now but by doing so, your priority date has also been lost. It also gets pushed by 6 months. So now you have a new priority date of 31st December 2023. Okay. So in this time gap, if Digisuki comes and he writes a research paper, you are screwed. You have lost your novelty now because your priority date has been moved. Your red flag will move from here to here. Okay. Is this much clear? Any doubts? Somebody had typed a doubt in the chat, I guess, right? Any other doubts?
I have some question.
Go on.
See, if the person is not able to file the complete specification within 1 year, then will that provisional application will be treated as anticipation for the other type of similar invention?
uh, that will come into play once it is published. Okay. So wait, I'll get to it. What you asked is a fantastic doubt. So I'll explain it to you when I explain to you publication. Okay. The last concept today I'll be explaining is publication. Okay. So what his question was wonderful actually. He said that once you've filed your application and once you've filed the provisional specifications, you get 12 months time, right, to file the complete. Failing which your application will be deemed abandoned, right? But now, does that abandoned application will that act as anticipation for your future application? The answer is no. But you'll understand it once I go to publication. Okay. I'll explain it. It's a fantastic question. Any other questions? Nothing, right? Cool. Uh, cool. So now you understood what is a provisional specification and you understood what is the controller's powers. So controller has three kinds of powers. Basically, when you have slight modifications or slight alterations, he'll allow you to file one complete spec in respect of all the inventions. If you request before the 12 months have passed, he will allow you to convert your complete spec into provisional spec so that you can make more changes. And he will also allow post dating. Suppose you realize that you do not have enough time and your deadline is approaching, you can request him for post dating. And the controller, if he is satisfied, he'll allow you to post date, but at the risk of you losing your priority date. Okay. Now, we saw provisional specifications. So what are the complete specifications? I know it's getting a little too much. Just follow along. So we'll discuss all of this in drafting. Okay. So when we do patent drafting, these are all the things that go into the draft. Firstly, the title. It has to be less than 15 words. The title of your invention. What is your invention in 15 words? What is the background of your invention? What is the object? What is the goal that you're trying to solve? What is the problem that your invention is trying to solve? What is the summary of your invention? What is the summary of your invention? What is the brief description of your drawings? As in, suppose you're submitting drawings of your robot or your new machine, you'll have to give the description of your drawings also. What does each figure say? What does each figure represent? Is it the isometric view, front view, top view? You'll have to explain it. Okay. Sometimes the controller might ask you to give even a 3D model. Okay. In which case you'll have to submit a model also to the controller. And in certain cases, suppose you're developing a form of microorganism, is it possible to completely convey or depict a microorganism using drawings? Right? It's not possible. In which case, you'll have to deposit a little bit of that biological material also. The controller will request you to submit a small part of that microorganism, which will have to be deposited in a repository. Okay, that we'll study next week. Leave it for now. But when you're talking about biological materials, he'll also request you to deposit the actual material also, because a drawing cannot convey everything that a biological material kind of wants to convey, right? And then the most important parts of the complete specifications, the detailed description and the claims. Okay, and lastly, you have the abstract, which has to be less than 150 words. Abstract is basically very simple to understand. It's just a short, crisp summary of your invention. Basically, reading that, you should get a good gist of what your invention is. Okay, not very important. The two most important parts are the detailed description and the claims. Okay, so your detailed description is the complete technical disclosure of your invention. You'll have to explain everything from how your sensor works, how the electronics are, what is the processing, how it takes info, how it processes the info, how it gives the output, what is attached to what moves what. Everything about your invention has to come in the detailed description. Okay, and this detailed description is used to supplement the claims. Okay, so your claims are the heart and soul of your invention. Okay, what you want to protect has to be written in the claims. Claim 1, claim 2, claim 3, claim 4, it keeps going on. Okay, your claims define the scope of the exclusive protection that your patent has. Without your claims, your patent is worth nothing. Okay, at least every patent has to have at least one claim. Okay, your claim is like, if you guys have gone through property papers in your internships now, at the very end you have a schedule, right? Basically, you define the boundaries of your property. North, it's 30 feet. East, it is 40 feet. West, it is so much. South, it is so much. It is bound by this road. It's bound by that building. So defining the boundary of a patent is your claim. Okay, and claims are the most important part of any patent application. So this detailed description plus the claims together must sufficiently and clearly describe the invention and the best method by which it is to be performed. Okay, so this is what I was talking about when the first doubt was asked about the disclosure requirements. So any reasonable person, okay, any person who's ordinarily skilled in the art, any engineer, after reading the complete specifications, after reading the detailed description of the claims, he should be able to recreate the invention. Okay, if he is able to recreate the invention, it means your complete specifications are complete. It is sufficient. Okay, it is clear and it is understandable by a person who's ordinarily skilled in the art. See, if a layman reads my patent application, he won't be able to recreate my invention. But if a person who's ordinarily skilled, if he's able to read the detailed description and the claims and my entire complete specs, and if he's able to rebuild my engine, or if he's able to rebuild my invention, or something, that means my specs have satisfied the disclosure requirements. It means my complete specifications are sufficient and complete. Okay, so this is the requirement. So if it is not complete, if it is not sufficient, you can challenge the application later on. You can say that the complete specifications are very ambiguous, they're very vague. It's not enough for me to understand, right? In which case, the application will be struck out and thrown out. Cool. Now, an example of what the claims might be. Let's say there's a robot arm. Okay. Let's say this robot arm has three components: a torque sensor, a motion tracker, and a vibration canceller. Okay. These are the three components I've incorporated in this robotic arm. Okay. So how I'll write claims for this is I'll write three claims for this. I claim or we claim. If I'm a company, I'll put we claim. And then I write three claims. Okay. Don't read what the claims are. I've just written it as an example that you can see later on. So I claim, firstly, in X, I claim the torque sensor. In Y, I claim the motion tracker. And in Z, I claim the vibration canceller. Okay. In each of the claims, I describe what the torque sensor does, what the motion tracker does, what the vibration canceller does, where it is located, and what its function is. Okay. If once I describe all of this, it becomes a single claim. Okay. So now I have three claims in this patent application. So without these claims, my patent is worth nothing, right? So the claims have to be solid and they have to withstand any test that is thrown on them. Anybody who challenges it, the claims have to withstand them. So what you need to understand is each claim is independent of the other claim. Okay. Let's say somebody challenges me and they say that, oh, claim number 3 is already there in my invention, and then claim 3 is struck out, right? Does that mean claim 1 and 2 is also struck out? No. Claim 1 and 2 will independently exist of claim 3. So what happens is a lot of times you file an invention with like 20 claims. Okay. And the parent office will strike out claim 3 is rubbish, claim 4 doesn't have novelty, claim 5 is getting infringed by this thing, claim 6 does not have inventive step, and they'll strike out a lot of claims. In the end, once they strike out all the claims, the remaining claims, those will always survive. Okay. So each claim exists independently of the other claims, and each claim also has a priority date. I'll explain that also in the next slide. Okay. So what very simple thing I want you to understand now is don't lose your mind over here is, let's say a vibration canceller already exists in the public domain, right? So that means there is no novelty or inventive step here. Claim number Z will be struck out by either the patent office, or maybe once it goes to court, the high court will strike it out. Okay. So claim Z does not exist. Does that mean X and Y also get struck out? No. I'll still have a patent on claim number X and Y, right? So I'll still be able to protect my invention with respect to these two components. Okay. Very simple. Okay. So when I talk about priority date of claims, I just want you to understand it. This happens in certain cases when you file a provisional application, right? When I file an application with only the provisional specs, right? I've not completed my R&D. Let's say in my R&D, I've developed only X and Y. Okay. And after that, I file the provisional specs. And after 1 year, within 1 year, I develop even Z. Okay. And then on the date of filing the complete specifications after 1 year, I also include Z as a claim. So don't you think this claim has been introduced very late? It has come very late, right? So let's say on June 1st, 2023, I filed the provisional specs with claim 1 and claim 2. So the priority date of claim 1 and claim 2 are the priority date of the application itself. So both of these, it's still June 1st only. And then within 1 year, before June 2024, when I file the complete specs, I also add claim number 3 also. In which case, since claim 3 came late, the priority date of claim 3 is June 1st, 2024. Okay. So what is the problem now? Claim 3 is at a risk of whom? Of Degisuki, right? If Degisuki publishes a research paper here with claim 3 in it, claim 3 will not get passed now because I've lost the priority date. It's a newer priority date. The priority date will be after the research paper. So claim 3 is at a risk of getting anticipated by another patent application or publication, right? So with the provisional specs, I don't have to file all the claims. Literally, you can submit the provisional specs with only your title and your abstract. You don't even have to give the detailed description. Only the title and abstract are needed for the provisional specs. Claims are not at all mandatory. In which case, when I make new claims in the complete specs, on the date of filing the complete specs, when I make any new claims that were not disclosed in the provisional specs, then the priority date of the new claims will be the date of the filing of the complete specification. On the date I file the new claim and I introduce it in the complete specs, that shall be the priority date of this claim. And even if claim 3 is struck out or it is anticipated by Degisuki, claim 1 and 2 will still stand. Okay, Degisuki can't do anything about those two. And in some cases, a partly disclosed claim. Let's say that claim 1, even over here, the torque sensor, it has not been fully developed. I filed the provisional spec for it, but I improve it. In 1 year, I add a certain few modifications to it and I make it a little better, right? In that case, when I file the complete specifications, I'll file it with a newer claim, right? Something which is slightly better. So the first claim is partly disclosed. It does not disclose the whole claim. So the partly disclosed claim, the incomplete claim in the provisional specs, if it's there, then and then I file a newer claim with all the newer details, then the priority date is moved to the date of the complete disclosure of the claim. So when I file X with the provisional specs and it's incomplete on June 1st, 2023, and I improve it, and then when I file it again on June 1st, 2024, so let's say claim 1 is modified and I've improved it, and I file it again on 2024, I improve it and I reintroduce it in this, then the priority date has moved to the date of the complete specification. Okay, very simple. When it is not fully disclosed, on the date of the full disclosure, when the claim is complete and it is final, that will be the priority date of that claim. Okay, that is pretty much a summary of that. Cool, that's it. We're done with it. Just last 2 slides. Any doubts regarding priority date and claims? Cool. Last 2 slides. I know everyone is like complete in Beja fry mode right now, but just 2 slides left. Don't shoot me. Basically, everywhere I kept putting this patent office is going to process, patent office is going to process, everywhere here, right? Patent office processing. What is this processing? Okay. So that's what we're going to see now. Patent office processing consists of 3 things. Basically, it does publication, it does examination, and lastly, it does opposition. Okay. So what is publication? So when you file a patent application in the patent office, it's top secret. Okay. Nobody other than you and so the person who's collecting the application, maybe he will know about it. Okay. Nobody knows until the publication happens. Okay. So what is publication? Publication is when your entire complete patent application is published for public view in the weekly patent and design journal on the IP India website. So the IP India website, every week it publishes all the latest patent applications. Okay, on this patent and design journal every week, every Friday. As in 2 days back, the patent and design journal had all the new applications on it. Okay, once it has been published on it, everybody in the public can see it, right? Once it has been put on this website, then it is deemed as published. Okay, only after the date of publication, only after it has been published, it this question of anticipation will come into play. Okay, so what the question he asked was, the previous question he asked was, let's say I withdraw my application or my application is deemed abandoned, will it act as anticipation for my future application? The answer is no. No. Why?
No, no,
Because huh?
not for your future applications, but
Mhm.
for the person who is working on a similar invention for the other person.
Cool. Huh. Okay, I got your doubt. So even for anyone for that matter, it will not be deemed as anticipation. Okay, for it to be deemed as anticipation, it has to enter the public domain, right? For it to enter the public domain, it should be published. So till it is published, it will never enter the public domain. It can never be anticipated. Okay, so if you've just filed you filed an application and you just withdraw it, or you let it lapse, you don't file the complete specs, so the application is deemed withdrawn or abandoned. In which case, it has not entered the public domain. It will never be anticipation. Okay, for it to be published, we will see the requirement. It has to let's see the process after this. So till it is published, it is not anticipated. Okay, examination is, can you file a patent on anything? Who do you think does the checking, right? So there's a patent examiner, like a controller, there's an examiner. So he's like a professor. He'll sit and he'll go through your application. He'll check, is there novelty, is there an inventive step, does it have industrial application, does it violate anything in section 3 and section 4, is it a nuclear bomb that you're trying to patent, and any other procedural compliance. Once all this is done, this is called as examination, done by an examiner. So how does he check for novelty? He checks, is there any publication? Has any Degisuki published anything before that priority date? Or he'll also check something very interesting. He'll check, is there any other patent application also which has been filed, right? Which has not been published. So let's say a patent application has been filed in the office, but it has not been published yet. Okay, it will be published in a few months or so, but has not been published. But some other application has been filed with the same claim. So he will also go through all the applications which have been filed, all the secret stack of applications which he has, which nobody knows about, all the top secret applications also he'll go through it just to check, is there novelty or not? Does any other application have an earlier priority date? Okay, don't try to understand it too much. You'll understand it as you study for the exam. Okay, basically checks for novelty, inventive step, industrial application, section C, section 4. Okay, and lastly opposition. So let's say Uttam is trying to register a patent in my application with respect to an invention which I already have. I already have a patent on that invention. Okay. Once the patent office publishes it, and I notice that Uttam's invention come up on this patent and design journal, I will file an opposition. Any interested person who wishes to oppose the grant of the patent can oppose it. Opposition as in I will submit an application to the controller. Controller will call me. He'll ask me what is the opposition. I will tell him Uttam's patent is going to infringe on my patent. I already have this invention. So there'll be an opposition proceeding which will happen. Okay. So these are the three things which happen. Just basic in depth of each thing. Publication is the patent application is published for the public view in the weekly patent and design journal on the IP India website. So any person, he can access everything, the drawings, the detailed description, the detailed description, the detailed explanation, the claims. You can see the claims. You can see everything for the patent application, right? So why is this not risky? What if somebody else copies it? It does not matter because your priority date is already established as the date of filing. Okay, so it is published for the public to view. Then after filing of the complete specifications, the patent application may be published. Okay, so you file the provisional specs with your filing. Within 12 months you have to file the complete specs. If you don't file it, what happens? It's deemed as abandoned, right? In which case it will never get published. So if it's not published, it cannot ever come under the public domain. It will never anticipate any new invention. Okay, so you'll have to file the complete specs. If it is deemed abandoned, it cannot be published. Okay, so the publication will happen automatically after 18 months from the filing of the application, or earlier at the request of the applicant. Let's say I file it on June 1st. Okay, in 18 months, suppose I filed the complete specifications also. In 18 months, automatically it will get published. At the end of 18 months, all the applications which are 18 months old will be published. Okay. In case I want a fast patent, I want to go for a very fast grant. In that case, I can make a request for an early publication. I'll have to submit a form. The controller, if he's satisfied, he'll publish my patent application much earlier. Okay. But 18 months, it will automatically get published, even if you don't do anything. Okay. So publication will occur automatically unless secrecy direction has been imposed. Somebody asked, right, what about defense related stuff? Will you get a patent on that? No, because if it is anything related to defense, secrecy direction will be imposed. It will never get published. You'll never get a grant on this patent. Okay, we'll study this next week. So if a secrecy direction has been imposed, it's something defense related, stuff like this, it will not get published. If your application has been deemed abandoned, as in you have not filed your complete specs in the deadline, it will be deemed abandoned. Of course, it's not going to get published now. And lastly, your application has been withdrawn within 15 months of filing. Okay, just 3 months are left before the 18 months, and it's automatically going to get published. Before those 3 months, before 15 months itself, you withdraw your application. Why will you do this? Okay, let's say you file an application for a new form of spectacles. Okay, some kind of x-ray vision spectacles that you file, and after 15 months you realize that shit, my invention is not great, I'm not going to get a grant on this patent, and I need to improve on it, I need to work on it, I need to make it better. Okay, but if you don't withdraw it, it's going to get published now, right? If it gets published, it'll get anticipated, other people will get to know about it, everyone's going to see your claims, your drawings, your detailed description, public will get access to it, right? But you don't want this to happen. You want to continue working on R&D, in which case you will file an application to withdraw your application. You'll file a form, you'll submit a form to withdraw your application within 15 months. So if you do it within 15 months, it won't be published. If you even waste one more day, if it reaches 16 months, even no matter what you do, it will be published automatically now. It will enter the public domain. Cool. So all rights of the patent holder start from the date of the publication. Okay, so once the thing has been published, you are in effect a patent holder now, right? Because the public has gotten to know that you have a patent on this. At least you have filed a patent application on this. Cool. Examination is again very simple. Like I told you, an applicant or any interested person has to make a request for examination within 48 months of date of filing of an application, right? So here what did I tell you? Publication is automatic, right? Publication will occur automatically within 18 months, after 18 months. But in examination, you will have to make an explicit request to make the examination happen. Okay, applicant or any interested person has to make a request for the examination within 48 months, as in 4 years from the date of filing of an application. So within 4 years, if you yourself don't go and ask for the examination, then your application will never get examined. At the end of the 4 years, failure to make a request will deem the application as abandoned. Okay, your application is dead. So FER, or the first examination report, is made by the examiner. So the examiner, what does he do? He checks for novelty, inventive step, section 3, section 4, all this rubbish, and then he'll make a report, an FER. Okay, so first examination report is made and it is submitted to the controller. Then the controller will raise all the objections. He'll tell you this claim is bad, claim number 4 is bad, claim 5 is bad, you have not done this, and he will order an amendment. He'll tell you to amend your application, and you will have to comply with this amendment order within 6 months. Within 6 months, you'll have to put your application in order based on all the changes which the controller tells you. And this 6 months can be extended to up to 9 months, extendable by another 3 months. Okay, and of course you will get a hearing. The controller will give a hearing to you where the applicant can come, he can respond to the objections. He'll say, oh, this is very unfair, my claim is still strong, this claim is not does not lack novelty, my claim is still sufficient, stuff like this. Okay, so once the amendments are made, and if the controller is satisfied and the FER has been responded to, then the patent might be granted. And suppose you fail to respond to the FER adequately, and if you don't respond to it in a satisfactory manner where the controller is not satisfied, then the application will be deemed abandoned. Okay, so examination is literally an examination where your patent application is fully evaluated. The examiner sits down and he completely dissects your patent application. And the last thing is opposition. Like I said, any interested person, as in who's an interested person, suppose another person who has a patent, okay, or another person who's working in the field, or another person who works in the industry, or a general person in the public who buys that product. Okay, let's say I'm buying anti-diabetes medicine, okay, and somebody is trying to file a patent on a diabetes medicine now, right? And I find out that this medicine is already available, in which case I am an interested party, right? So any interested person may submit an application to the controller before the grant of the patent or after the grant of the patent. So before the grant of the patent means it's pre-grant opposition. After the grant of the patent means post-grant opposition. Okay. So pre-grant means till the grant, I can file pre-grant opposition. After the grant means post-grant opposition. Okay. Why this is important is in post-grant opposition, an opposition board is created. Okay. A 3-member board is created by the controller, and this board investigates, and it's done. The procedure is very formal. Okay. Apart from this, on what all grounds can you oppose a patent? Okay, just there are a lot of grounds in section 25. You can just glance through it. Basically, pre-grant and post-grant, the grounds are the same. If the invention is wrongfully obtained, suppose I've stolen the invention, I've stolen it from Subramaniam and I'm trying to file the patent, or my invention is not novel, Digisuki has already written a research paper on it, or if it is already publicly known and worked, as in like turmeric's wound healing properties, it's already publicly known, right? So the US can't grant a patent on it. Or if it lacks an inventive step, this is something that is very obvious to a person, right? Or it's not an invention at all, bloody it's some natural law, or it's a law of physics, or somebody like Satyanarayan is trying to patent a religion now, right? Or if the complete specification is not sufficient, it does not enable me to recreate the invention. As an ordinarily skilled person reading the complete specs, he's not able to recreate the invention, right? That means it fails the disclosure requirements, it's not sufficient, right? In which case the patent can be opposed. Then failure to comply in the international application. So there are certain procedures requiring an mandating for an international application. We'll see it next week. Apart from that, I told you, right, when you have a biological material, you'll have to deposit the biological material also in a repository. So if you wrongfully mention the source, or if you do some rubbish with respect to that, you don't comply with the procedures there. Or something with respect to traditional knowledge, you cannot patent traditional knowledge. Okay, so they just give you a wide range of grounds on which you can oppose. They're not completely different from each other. They're a combination of each other. Okay. Then lastly, the controller, once somebody files an opposition, he gives a notice of the opposition to the applicant, and he gives an opportunity of hearing to both the parties. He'll hear this party, the person who's opposing, he'll give up no hearing to the person, the applicant himself, and then he'll sort it out. Okay. So as long as you have opposition, the patent office procedures will keep continuing. Once it's all complete, once it's all fine, you can go for grant and you'll get the grant of the patent. Okay. So this brings us to the end of this patent basics meet. Any questions regarding the patent office procedures?
Yeah. Can you once repeat the differences between the functions of controller and examiner?
Okay. So like I told you, controller is like a chief. Okay. A controller is like the king of the patent office. So examiner is like his minister, like his soldier. So the controller can't sit and evaluate everything. So in examination, so when you guys do your IP related internships, suppose you go for FER response, or when you go to responding to, when you go for novelty search, patent search, stuff like this. So what the examiner does is he takes your patent application, he reads your invention, he understands it. Then he uses a patent database and he searches for all the similar inventions. Okay, he searches for anything which is related to your invention. He tries to identify, is it copying something, is there any other research paper related to this. So it's going to be days and days of research, right, where he's trying to see, is it anticipated, is it truly novel, is it inventive. So do you think the controller can sit and do this week long research for every patent application? So he hires a controller examiner to do this for them. So the examiner purely does the examination work. The controller does all the administrative work, as in like any request will go to the controller. Even here, the controller will order the examiner to do the examination. Once the examination report is made by the examiner, it's again submitted to the controller, and the controller will give the objections. So every exchange that you have will be with the controller. Okay, examiner is merely the soldier of the controller. He's the controller's assistant. Think of it like that.
Okay.
Yeah. Any other questions? Cool. Okay, I know it's a lot to take in at the same time, but what can we do? It's a big subject, right? You can't teach everything in 2 hours. Cool. Uh, Stop presenting. Cool then. I did cover all the basics. If you guys have any other doubts, you can of course put it up on the group. And unfortunately, I was not able to record the video. I was going to upload it on YouTube. Yeah, Subramaniam, Satyam, anything?
Yeah, Vishnu, do we need to prepare entire Patent Law Bare Act or only a few sections? If there are only a few sections, can you give me the list of those sections? Because
See,
I think we had a word on that.
See, once you've understood the concepts, right? What is priority date? What is provisional specs? What is complete specs? I've also highlighted the section names in the PPT. Just read through all the sections. Literally, you need to know the whole act. Okay, the whole act has around 150, 160 sections. Okay, but you can combine all the sections. Like literally, one section 130 to 160 is all about international applications. Section 120 to 130 is all about patent agents. 100 to 110 is all about the infringement proceedings. Section 80 to 100 is all about compulsory licensing. Section 1 to 5 is all about what are not patentable. We already saw it, nuclear, this, that. So once you start combining the sections in your mind, it's not a lot. You basically have around 10 or 12 groups of sections to cover. Okay. And once I've explained the concepts, it's very easy. Once you read it, you will understand it for sure.
Yeah, thank you.
But in general, for the patent agent exam, you'll have to know the whole act. So definitely read through the whole thing. Any doubts, please come back to me. Okay. Definitely you'll get a lot of doubts. This exercise was just so that you get a basic idea of all the concepts. I think we have covered every basic concept that's there. So next week we'll be covering all the advanced concepts and we'll be covering all the international procedures. Okay. And we'll be covering what else was left from today's class. Apart from that, anything else you guys want to ask? Nothing, right? Cool. So I'll share a little bit of material. Read that and come for next week. Okay. That's about it. Cool. See you guys then. Bye bye. Tata.
Thank you, bhai.
Thank you.
Thank you.
Thank you.
Thank you, bhai.